To proceed. So this session will be about Bab Sifatul Hukm, or the chapter on the manner of judging or court proceedings. Imām Qudāmah rahimahullah, who died in the year 620 after the Hijrah, said in his book al-Umdat, which is a Hanbali primer, إذا جلس إليه الخصمان فادعى أحدهما على الآخر لم تسمع الدعوة إلا محررة تحريرا يعلم به المدعى عليه. When the two litigants sit before him, the judge, and one of them makes a claim against the other, the claim will not be heard unless it is accurately detailed and the details are revealed to the defendants. Okay, and then he will explain what he means by this. So he says, فإن كان دينا ذكر قدره وجنسه وإن كان عقارا ذكر موضعه وحدوده وإن كان عينا حاضرة عينها وإن كانت غائبة ذكر جنسها وقيمتها. If the subject of dispute is a debt, he must mention its amount and type, silver coins, gold coins, this or that. If it is real estate, he must mention its location and borders. If it is a particular item that is present, he must point it out or point to it. If it is absent, he must mention its type and value. Okay. So basically, the claim, and that is why, because court proceedings is a big issue. That's why you need lawyers most of the time nowadays, because court proceedings, you have to make your claim in a way that is comprehensible and that is legible and so on. So he's saying that the claim has to be basically detailed, has to be clear and detailed. And the subject of dispute has to be pointed out and has to be, if it is present, you have to identify it. If it is absent, you have to talk about type and amount and value and where it is and all of that stuff. You have to give all the details. So you don't go to make a claim before the judge without being ready to make your claim. Get your act together, your ducks in a row, and then go. Don't go to the judge basically to waste their time. That's what they're trying to say here. In fact, the da'wah or the claim has other conditions. It has to be muharrara, detailed, it has to be ma'luma, identifiable. It has also to be muta'alliqa bil hal. It's about something that is existent now. So, it's not about something that may happen in the future, or the legal consequences of it are not due now. Also, it has to be it has to be munfakka amma yukadhibuha. It has to be there should not be something to basically invalidate your claim. The claim should be a valid claim. A claim that is obviously invalid may not be heard to begin with. Like if you say that this guy stole my car 25 years ago. That means what? He was 5 or 7 when he did. That claim will not be heard. Things like that. So it has to be munfakka amma yukadhibuha. In fact, that is an area here that can be used nowadays. Like people who are clever or technical, they may use this area. And the da'wah labudda an takun munfakka amma yukadhibuha. That has to be. For instance, to deny someone the right to li'an, That's public imprecation. You know li'an, public imprecation, that's mutual cursing. That's when a man accuses his wife of adultery. Okay. They may say, have the DNA test done first, and if the DNA test shows the child to be yours, you cannot basically establish the claim to begin with. You cannot go to court. The court will not hear your case if the DNA test shows the child is yours. I'm not saying that this is right. I'm just telling you that this is something that is being discussed. If someone comes to deny the paternity of a child, traditionally, what is the process? Li'an, public imprecation. Okay, now that we have DNA testing, can we force them to get the DNA test first? Everybody says yes, force them to get the DNA test first. But then the scholars will disagree. Would he be still entitled? Keep in mind that this is denial of paternity. This is not only accusation of adultery, because accusation of adultery is a different thing, but this is denial of paternity. Can you, after the DNA test is done, hear their case and give them, the right to public imprecation or not? That's the question. Some of the scholars said that if the DNA test shows the child to be his, you don't hear the case. You close the case. You refuse to listen to him. Anyway, that's something that they talk about. But also, the certain cases, like al-Wasiyya, someone bequeathed something, or someone acknowledged that he owes you something, but it is not basically determined what it is. It's not ma'loom. It's not known. The value of it is not known. Can you make that claim and say, so-and-so bequeathed something to me, but it is unknown, majhul? Yes, in these cases, in these exceptional cases, your case would be heard, can make that da'wah, that claim, even though the subject of dispute is unknown. Okay. Also, one of the things that may be said here, they did not hear a case unless there is an opponent. In the Hanbali madhab in particular, you don't hear a case when there is no opponent. There has to be an opponent. Except in certain cases, like to establish a waqf, for instance, no opponent, because the waqf is owned by Allah, and so on. What if someone wanted to come and basically claim ownership of a particular property, and there is no disputant? You hear that case or you don't? The Hanbalis said, no, you don't. There's no disputant. The idea here is that you have to also understand that the judge in town had finite time, and people had, they were also cognizant of the need to not overwhelm the judge in town. So that's why they're talking about claims and which cases you would hear, because otherwise all the people in town would be sitting, with the judge, the 24/7, discussing their issues and So they have to identify which cases may be heard to prevent that overwhelming the system. Now, Imām Ibn Taymiyyah rahimahullah said you can hear a case without a disputant to prevent the dispute in the future. You know what is this now called? It's called the مصلحة الشهر العقاري. It's called county recorder. County recorder. County recorder basically is where you go to establish ownership of a particular property. No disputant, but you just want to establish your ownership of this property. That is why you're recorded in the county. مصلحة الشهر العقاري. So that مصلحة الشهر العقاري is, in a sense, part of the judiciary. And they, like in Egypt, for instance, they are under the Ministry of Justice. So they do recognize that it's part of the judiciary. Okay.
About those who are exiled. About those who are exiled can be present in proceeding. Those who are exiled.
Exiled?
Yeah, and there's a proceeding against them.
Oh, those who are absent.
Yes.
Yes. Can you basically hear a case against someone who's absent? Yes, you can hear a case against someone who's absent if he's far away, and if there is bayina, proof against them. If they are within masafat qasr, if they are close by to town, you have to bring them. You can't hear the case against them without their presence. But if someone is absent or someone is hiding, you will have to hear the case. Because otherwise, the rights of people will be lost if you don't hear cases, because someone can just simply hide so that the case is not heard against them. You will have to hear the case, and if there is bayina, if there is proof, you judge against them. Now, which case is this? Cases that have to do with the rights of man, not cases that have to do with the rights of God. So you don't hear a case against someone that he stole. You could hear the civil case, meaning what? The person is basically claiming a right to the value of the stolen item, not the punishment for theft. Punishment for theft is the right of God. The right of the person from whom something was stolen is to get the value back of that which was stolen. You can hear the civil case. You cannot hear the criminal case. Can the absent? Can you hear a case on behalf of the absent? Not until he makes tawkeel, gives power of attorney, or hires an agent to speak on his behalf. In this case, you can hear it. Now, you could hear a case of someone who's absent. You can hear a case of someone who's absent if he is one of several claimants. Like if it is not just about him. Like let us say it is a case to establish the passing on of inheritance, and he's one of many heirs. Or say a case to establish that a waqf, an endowment, belongs to a particular people, and he's one of the people. Then as one of the claimants, you could hear the case because there are others who are present. But in general, you can't hear a case on his behalf by him without an agent, and a case that's against him. If he's close to town, you will have to bring him. You will have to order him to come. If he doesn't come, he's hiding, or he's far away, absent, and can't come. In all these cases, you hear the case in their absence. This is still a little controversial between the madhahib. What I'm giving you now is the authorized Hanbali position. All right, then the Sheikh said, okay, so you will have to basically make a detailed, clear claim for your case to be heard. You made your detailed, clear claim against the disputant. Then the judge, the Sheikh said, ثم يقول لخصمه ما تقول فإن أقر حكم للمدعي وإن أنكر لم يخلو من ثلاثة أقسام. Then he will say to his opponent, after the claimant made the claim, the defendant now, it's time for the defendant to speak. He will say to his opponent, what do you say? If he admits the charges made by the claimant, a ruling will be made in favor of the claimant. If he denies them, then there are only three possibilities. We're talking here about disputing over an item or property. Disputing over an item or property. What are the three possibilities that you can imagine? It's about who has possession of it, in whose possession the item is. So if one of them, there's just three different scenarios here, and he will go over them one by one. One of them has it. Both of them. Like how? Like a property in which both are residing, for instance. Both are residing in this property. Or someone who comes in with a garment, two people come into the room with a garment holding to it, you know, from both ends. They both have possession of it. Okay, and then third party has possession of it. Not the claimant, not the defendant. Someone else has it. Okay, so the first one of them has it. Then he says, أحدها أن تكون في يد أحدهما فيقول للمدعي ألك بينة فإن قال نعم وأقامها حكم له. The first, the subject of dispute, is physically in the position of one of them. In this case, the judge would ask, that's the defendant, by the way. The judge will ask that because you know, if he has possession of it, he's not the claimant, he's the defendant. The judge will ask the claimant, do you have proof? Do you have two witnesses? Do you have a document? Do you have proof? If he says yes and establishes it, his proof, then a ruling will be made in his favor on this basis. Okay, he established the proof. Now, وإن لم تكن له بينة قال له فلك يمينه فإن طلبها استحلفه وبرئ لقول رسول الله صلى الله عليه وسلم لو أعطي الناس بدعواهم لادعى ناس دماء رجال وأموالهم ولكن اليمين على المدعى عليه. Okay. If he has no proof, the judge will say, you're entitled to have him take an oath of denial. If the claimant demands it, the judge will ask the defendant to take the oath and thereby be acquitted. This is because the Messenger of Allah ﷺ said, if people were given whatever they claimed in disputes, some people would claim the lives and wealth of others. But the oath of denial must be taken by the defendant. The hadith actually, the Prophet is saying here, the oath of denial is not to be given to the claimant, because anyone can take the oath and then claim whatever they want. The oath is to be given to the defendant. But what the hadith is saying that you're not reading in the wording of the hadith is al-bayyina ala man idda'a. That's why there is, sometimes this hadith is reported ولكن البينة على من ادعى واليمين على من أنكر. But the proof will be the duty of the claimant, or will be on the claimant, responsibility of the claimant, and the oath of denial will be given to the defendant. So that is the case. So you are the claimant, you came and said, this person resides in this property, but it is mine. He is residing in this property with his family. The property is mine. We will tell you, establish your proof. Well, what is your proof? He will say, here are two trustworthy witnesses who attended the basically contract of sale when he sold me this property. Okay, good. What if you have no proof? And you say, I had the document, I lost it. But wallahi, it is mine. Then what do you do? In this case, just to be, because the ultimate thing, the bedrock of the Islamic system is what? Justice. You're trying to reach justice by any means possible. You are counting that human beings, no matter how wicked they are, they have something good inside them. Like you're trying to tap into that. You say to the defendant, take an oath. Someone will say, what does that mean, take an oath? Yes, because this is the dipper. This is al-Yamin al-Ghamus, the dipper that dips you in the hellfire. And in fact, there are reports of people being reminded during the court proceedings of the hadith of the Prophet ﷺ about the Yamin al-Ghamus, the dipper that dips you into the hellfire, and about the gravity of this, and basically walking away, or like testifying against themselves in this case. So you will say to the defendant, okay, the claimant was not able to establish proof. Would you take an oath that this house is actually yours? Would you take an oath that this house is actually yours? If he took the oath, that's it, done. He gets to keep it because the claimant did not establish a proof. And he took an oath of denial. If he did not take an oath, that's what the Sheikh will talk about now. What if he did not take the oath, refused to take the oath? Then he says, وَإِن نَكَلَ عَنِ الْيَمِينِ وَرَدَّهَا عَلَى الْمُدَّعِي اسْتَحْلَفَهُ وَحَكَمَ لَهُ وَإِن نَكَلَ أَيْضًا صَرَفَهُمَا. If the defendant declines to take the oath and passes it back to the claimant, the judge will demand that the claimant take the oath, and if he does, he should judge in his favor. However, if the claimant also declines to take the oath, the judge will dismiss them both. Dismiss them both. What does that mean? Keep in mind, before that we said that the claimant has to ask for the defendant to take the oath. The judge does not automatically say to the defendant to take the oath until the claimant asks for the defendant to take the oath. Why is that? Because the claimant will have that chance once. He can't bring him back to court to demand another oath. He will have that chance once. He cannot bring him back to court about the same, that will be double jeopardy, about the same case, to take another oath. So he has to request it willingly, the claimant, because he's entitled to it once, that chance. Now, this position that he's saying here, he resides in this. The claimant came, this is my house, failed to produce proof. The resident in the house was asked to take an oath. The resident refused to take an oath. He is saying, and that is the weaker position in the madhab, which to me is a very good position. He's saying that when the defendant refuses to take the oath will go back to the claimant. If the claimant now takes it, because the claimant initially did not take an oath, he just made a claim. And then when he failed to produce proof sufficient, that is, because he can produce proof, but it is not sufficient proof. Okay, but when he fails to produce sufficient proof, then the oath will be given first to the defendant. And if the defendant takes the oath, that's it. He has possession of the property, he took the oath, the claimant could not establish the proof, done. If he declines to take the oath, then the oath goes back to the claimant. The oath goes back to the claimant, and he will have to take the oath to take the property. The judge will rule in his favor only when he takes the oath. That is the weak position in the madhab. That is he mentioning here. In the strong position in the madhab, in the authorized position in the madhab, the oath will not go back to the claimant. Why is that? All of this is because of this hadith. وَلَكِنَّ الْيَمِينَ عَلَى الْمُدَّعَى عَلَيْهِ. But the oath will be on the defendant. The oath would be on the defendant. In the authorized view of the madhab, they took this to heart and they said there is no oath for the claimant. The hadith does not talk about an oath for the claimant. The claimant has to produce proof, but does not take an oath. So the oath will be only for the defendant. If the defendant then declines, then we will give the claimant the property. Because an-nukul, denial to take the oath, or declining to take the oath, refusal, is an indication that it is not his property. Why is he not taking the oath? Keep in mind that it is very possible with people who are extremely, extremely righteous that they would decline taking the oath despite being entitled. And it actually happened once when Zayd ibn Thabit bought something from Abdullah ibn Umar that was defective, and they went to Uthman. Zayd said he sold it to me knowing that it is defective. Ibn Umar said, no, I did not. Uthman said to Ibn Umar, would you take an oath that it was not that you didn't know it was defective? Ibn Umar declined. This is Ibn Umar. It's not it's not you and I. It's Ibn Umar. So it is very likely that because they used to basically glorify Allah to such an extent that they would not take an oath, even if they would lose money, even if he would lose a case. Just taking an oath by Allah subhanahu wa ta'ala makes them shiver. So he would not take the oath. And he lost the case just because of his scrupulosity, that's because of his cautiousness, that he wouldn't actually take the oath. So, in the authorized position of the madhab, yes, it looks like this is what it is. The hadith said, وَلَكِنَّ الْيَمِينَ عَلَى الْمُدَّعَى عَلَيْهِ. The oath would be on the defendant. But this understanding that, based on this position, that the oath would go back to the claimant, is considering what? That the defendant may be afraid of taking the oath because he's unsure, or because he's too pious to take the oath. Send it back to the claimant, because he is making a claim. This is in the defendant's position. He is making a claim, and he hasn't taken an oath yet. It is only fair that we send it back to the claimant. Take the oath. Okay, you're asking the defendant to take the oath. You failed to produce proof. You asked the defendant to take an oath. He did not. You take it. And once you take it, take the property. Now, so I actually like that position, although it's not the authorized position. If they both decline taking the oath, what happens? He dismisses them. What does that mean? The defendant takes it. It isn't the position. It isn't his position, so he keeps it. Yes. Then the Sheikh said, وإن كان لكل واحد منهما بينة حكم بها للمدعي. If they both have proof, he will judge in favor of the claimant. He will judge in favor of the claimant. This is another also interesting point. So you have the defendant who resides in this house. The claimant established the proof that they own the house. The defendant established an equal proof that they own the house. Okay, that's conflict of proofs now. تعارض البينات. So what do we do now? If the proofs are equal, then he says, you give it to the claimant. Keep in mind that there is another position in the madhab which is not that weak. You can't even call it, I think I give it like a capital A2 here. Because it is actually a strong position, it competes with this position, that you will give it to the defendant. And that's the position that I believe in. You give it to the defendant. You don't give it to the claimant if they established equal proofs. Why? So what is the rationale behind both positions? Well, the position that I support, you give it to the defendant, is obvious. Because he has yad plus bayyina. Yad is what? Position. He is in possession of this property. Bayyina is proof. He has both. And the claimant has only what? Bayyina. But he doesn't have the yad. Okay, so that's clear. That's easy. So why are the other scholars saying that you give it to the claimant? Because he wouldn't have come unless there was, he had the confidence. He wouldn't have come to court unless he had the confidence that there is injustice here, that the person who is in possession of this property is, and then they say that if you are in possession of the property, producing a proof would be easier on you and things of that. It's harder on the claimant. So anyway, but at the end of the day, it seems that the other position in the madhab is stronger. If you have yad then bayyina, if you are in position and you have proof, you beat the person who has bayyina only but does not have yad. Okay, next scenario, both of them have possession of the item. How come? Holding one garment from two different ends, residing in the same household. Both are residing in this household. Okay. Where the so there is the one part here that we missed. وإن أقر صاحب اليد لغيره صار المقر له الخصم فيها وقام مقام صاحب اليد فيما ذكرنا. If the person who is in possession of the disputed property acknowledges that it is owned by another party, then that party, instead of the one who possesses it, will be the claimant's opponent. Okay, so the claimant came and said, this house is mine. The defendant that is in possession will say, no, this house is X's, which is a third party, not the claimant or the defendant. It is easy, it's simple. The claimant will be, the opponent, the khasma of the claimant will be X. Not the one in possession, but X. Then the Sheikh talks about the second scenario. Both of them are in possession. والثاني أن تكون في يديهما فإن كانت لأحدهما بينة حكم له بها. The second, both of them have physical possession. In this case, if either one of them has proof of his entitlement to the disputed property, the judge will judge in his favor on the basis of that proof. So both of them are, they are living in this house together. One has proof, one does not. Give it to the one who has proof. Simple. Okay. وإن لم يكن لواحد منهما بينة أو لهما بينتان قسمت بينهما وحلف كل واحد منهما على النصف المحكوم له به. If neither of them has proof, or if they both have proof, it will be divided between them. Each of them will take an oath concerning the one half he is granted. Okay, they both live in this house. Each one of them produced proof, or they could not produce proof. Neither one of them was able to produce proof. Then what do? Split it. Give each one of them half of it. Yeah, it's justice. It's, how else? Then each one of them will take an oath to deserve the one half. وإن ادعاها أحدهما وادعى الآخر نصفها ولا بينة قسمت بينهما واليمين على مدعي النصف. If one of them claims to own the entire property while the other claims to own one half of it, but there is no proof, then it will be divided between them. The one who claims one half will be responsible for taking the oath. The one who claims one half will be responsible for taking the oath. So they both live here. One came and said, we co-own it. One said, I own it alone. I alone own it. Then who's going to, we will split it between them because they have possession and they failed to produce proof. So we will split it between them. Okay? Who takes the oath in this case? The person who claimed that he co-owns it will take the oath. He's the weaker party in this. Weaker party, because the default is that one person owns it. The default is that there is no partnership and one person owns it. So if someone comes and says it's all mine, and someone came and said we co-own it, the person who says we co-own it, he will have to, because he's admitting that the other person owns part of it. So he's admitting that the other person owns half of it. And we will give the other person half of it, right? So why do we ask the other person for an oath if the other guy is admitting already that he owns half of it? So we will not ask him for the oath. We will ask the person who says we co-own it to take an oath to deserve one half of it. To deserve one half of it. Then the Sheikh said, and this is, you may disagree with this, but keep in mind, this is fiqh, this is one madhab, there could be another madhab that has different thoughts about this. وإن كانت لهما بينتان حكم بهما لمدعي الكل. If they both have proof, it will be given to the one who claims to own the entire property. Because that's the default. Is that one of them owns it, and there is no partnership. Otherwise, there would be some proof of that partnership. Otherwise, people receive property through inheritance, and they may not have proofs and stuff. But if there was partnership between them, likely there would be some document or some proof, witnesses, that there is actually partnership here. الثالث, okay, this is the second scenario. What about the third scenario? Neither of them has it or is in possession of it. Third scenario, أن تكون في يد غيرهما فإن أقر بها لأحدهما أو لغيرهما صار المقر له كصاحب اليد وإن أقر لهما صارت كالتي في يديهما. The third, it is in possession of a third party. If the possessor acknowledges that one of them or another person owns it, then the one who he acknowledges as the owner will be in the position of the one who has possession. If he acknowledges that they both own it, it will be like the example where they both are in possession of the disputed property. So, they are both claiming that this house is theirs. Someone else lives in that house, not the claimant or defendant. A third party lives in that house. If that third party says, if that third party said, there's no claimant or defendant here. They're both claimants, because no one is in position to be the defendant. Third party is in position. If that third party said, it belongs to X, X becomes here the one who has position. So Y has to establish the proof. X only need to take an oath. Is that clear? Okay. If that person who lives in the house said it belongs to them both, then it will be like the scenario where both are in possession of it. We will ask them for proof. If they produce or fail, both produce, both fail, what do we do? Split it. Okay. What if the person who lives in this house said, I don't know who owns it? وإن قال لا أعرف صاحبها منهما ولأحدهما بينة فهي له وإن لم تكن لهما بينة أو لكل واحد بينة استهم على اليمين فمن خرج سهمه حلف وأخذها. If he says, I don't know which one of them is the owner, and one of them has proof, it will be his, of course. If both have no proof, or if they both have proof, they will cast lots to determine which one will take the oath. He whose lot comes out first will take the oath and thereby take the disputed property. Or you could split it.
Yeah.
Right? But this is the position in the madhab. In this case, he will say, I don't know who owns it, and they have no proof. So we will tell them, okay, then cast lots, and that is also justice, because that's random. Cast lots. And whosoever's lot comes out then will take the oath and deserve it. Okay, that's pretty much that chapter. In this particular area, they discuss also some other issues, a couple of issues that we will talk about before we come to conclusion here. What if the judge, what if the ruler asks the maybe this is going to be like too long if to talk about this, but when it comes to the ahkam and people having different madhahib, when is it in the Hanbali madhab? When is it can you nullify the ruling of a different judge? When is it can you nullify the ruling of a different judge? If his ruling was in conflict with the Quran or Sunnah Sahiha or al-Ijma'. If his ruling is in conflict with the book of Allah, the clear, authentic Sunnah of the Prophet ﷺ or al-Ijma', then you have you nullify that ruling. Okay. But what if someone comes to you with a marriage contract, for instance, that happened without a guardian? Can you as a judge nullify this? A marriage contract that happened without a guardian. if you're a Hanbali, this marriage is fasid or sahih? Fasid. Yeah, it's invalid.
Is it depend on tayyib and bikr?
Not in the Hanbali madhab, no. Yes. So a woman has to have a guardian. That guardian, if it is not, family member, then it will be the Imām, or the Imām in the sense of the ruler, or the deputies of the Imām and the judges and so on. Okay, it's a little bit tricky here, because if that ruling is established merely by the claim of the couple, you have the right to pass it, you have the option to accept it or reject it, because their claim is not sufficient to establish that a full-blown judge, which would be in this case Hanafi judge, ratified that marriage, or sahah, accepted, validated that marriage. Okay, now if they have a document from that judge proving, or they have witnesses proving that that judge did actually validate their marriage, do you have options? No, you don't have options. Yeah. Why?
It's just, I think it's about have a marriage and then nullify it.
No, he doesn't have the option to nullify it. He cannot nullify
I
it.
think it wasn't a marriage. I mean, it's worse than that.
No. He is, in this case, he doesn't have the option to nullify it. He will have to enforce it. It is basically an enforceable marriage, even though in his book, yes, even though in his book it is not a valid marriage, that judge will have to himself enforce it, even though he believes in his book this is not a valid marriage, but he will have to enforce it. Why? Because it has been established before him that a legitimate judge validated it. According to the other method, a legitimate judge validated it. Yes?
For the first case, where they do not have a full-blown judge validating the marriage, why are they requiring that full-blown judge do this? I'm trying to obviously think in our context here.
Because it is not ratified by a judge, and reversing a judge ruling is not acceptable unless they have basically departed from the clear, established sunnah. And la nikah illa biwali is controversial. That's the whole thing. La nikah illa biwali, there is no marriage without a guardian, is controversial. The traceability of this to the Prophet ﷺ is controversial. Now, if this was validated by a judge, you do not reverse the judge's validation of a marriage without a guardian, because the ruling of the judge, it's a validation by a judge. That is huge. You can't reverse the judge's rulings, because that will lead to chaos, except if the judge makes a ruling, and that's why you have appeals and stuff like that. If the judge makes a ruling that is counter to qiyas, it is in conflict with the clear-cut Quran or Sunnah. This Sunnah is controversial. The traceability of this hadith is controversial. So that is why, but if there was no judge and they just got married without a wali, no judge validated this marriage, then they come to you as a judge then you have the option. And basically, if they're not having a good marriage, then you could just.
Sure, you asked that.
Why would
Huh?
they come to you if they want to keep the marriage? Why would they come to the judge if they want to keep the marriage?
They came to the judge because they wanted to validate the marriage because they heard that someone says you guys are not married, for instance. They want the judge to validate the marriage for them. Yes.
But
Of course, keep in mind, the fact أحكام الصحة والفساد, this is different from sin and, طاعة والمعصية and so on. Of course, if their ijtihad in their mind, they are married, they're not going to be in zina. It is in their marriage it is in their mind, and that they truly believe that they are married. So no one was saying that they would be in zina. No one would be saying that their kids are not going to be their kids or attributed to them. No one is saying this. It just, it's the difference in the conditions of marriage. These are the conditions that are required for the marriage to be valid according to the Hanbali madhab. You did not respect them. So in the Hanbali book, which is also the Maliki book and also the Shafi'i book, this marriage is not a valid marriage. Although the Malikis have some nuanced discourse over this. But they will, if it is validated by a judge, they will not reverse the judge's ruling. You do not reverse a judge's ruling unless it is in conflict with the clear-cut Quran, Sunnah, or Ijma'.
So, what about situations like does the couple have to be on the same madhab, for example, as the judge? Or if I'm living in a country and the country is Hanafi courts, should I basically revolve my life around the laws of the Hanafi because I'm going to be judged according to that, even though I may be personally?
No, you don't have to. You don't have to in your personal conduct, in your personal practice. But in anything that will bring you close to the court system, you want to be acquainted with the particular madhab of that country and the laws of that country, just to avoid the trouble with the law.
Based on that, Sheikh, I remember a while back we talked about this.
But keep in mind that, in our times, I'm sorry. Keep in mind that in our times, most countries, they select from the different madhab. Yes, then.
I was going to say, based on that, a while back we talked about this case in India where there was a married couple and the father of the son raped the wife, and because of that, the judges ruled that their marriage could no longer be valid. Can they just not agree to that? I mean, it's going to break up a family, right? So.
Okay. So can they just not agree to that? If they are Shafi'i and they truly believe in the Shafi'i position in this regard, it is disliked for them. So the ruling of the judge, does it make the thing in and of itself, does it change the ruling of the matter in and of itself or not? So a judge, for instance, says that this marriage is valid. Does it change the ruling that is make it valid or invalid? Certainly we're not talking about departure from the consensus here. Let us say that a judge deemed your marriage valid. The judge's ijtihad changed, and the same judge now thinks your marriage is invalid. That's not your problem. Your marriage is still valid. Let us say a judge told the mujtahid that your wife is not your wife anymore. Like told the mujtahid who believes that 3 divorces are one, that the judge believed 3 divorces are 3, he told him that your wife is not your wife anymore. Is that mujtahid now bound to accept the judge's ruling? For الظاهر, yes, the judge can enforce this. For الباطن, what is the ruling for this mujtahid? They say يكره له أن يخالف ما قضى به الحاكم. It is disliked for him to violate the order. Even for الباطن, it is disliked, but it is not like if he continues to be with this woman after the judge passed a ruling that it is not his wife anymore, it is not haram, it is disliked. The mujtahid himself, if his ijtihad changes, he has to follow his ijtihad. Like if he married a woman according to one ijtihad, and his ijtihad changes, he has to follow his ijtihad. He has to correct, renew the contract, or follow his ijtihad.
But in the case of
If someone judges for a Hanbali, for instance, like if a Hanbali sells matruk التسمية to a Shafi'i, sells meat that is not, if a Hanbali purchases meat from a Shafi'i, and the name of Allah is not mentioned on this meat. For the Shafi'i, this meat is halal. For the Hanbali, this meat is not halal. If the judge goes and validates the purchase, the Hanbali does not have the option, in this case, to say that I don't owe him money because he sold me haram meat, which has no value. He cannot even lie in an oath or equivocate in an oath to say that I owe him no money because of his ijtihad, that actually the meat was not. So you know that the Hanafis give shufa, the right of preemption, to neighbors. Right? The Hanbalis and the Jumhur, when the borders are set between, and there is no common property between them that they share, and the border, they don't give right of preemption to neighbors. The neighbor can sell his house to whomever he wants. The Hanafis give haqq al-shufa bil-jawar, the right of preemption to neighbors. He gets first dibs on this house because he is the neighbor, according to the Hanafis. Now, if you are a Hanbali and your neighbor sells the house to someone else, and you know that you live in a Hanafi district, the judge is Hanafi, can you as a Hanbali go and claim the right of preemption? It's controversial. Imām ibn Taymiyyah rahimahullah said you cannot, because in your book you're asking for something that you're not entitled to. It's not your right. But he says he agrees with the rest of the Hanbalis that without you asking, if the judge gave it to you, you can take it. But you can't ask for it because it's not yours.
So, in the case that I was mentioning, though, how can someone's ill intentions and actions then cause you to have to be bound by a ruling that, it just seems kind of unfair for you to be bound by? like, why would a judge look at that case and be like, okay, your father had, relations with your wife, so now that's it, like, your marriage is nullified. Like, it wasn't done, it's not like they were married before they got divorced, now the son wants to.
No, but this is not ill intentions or anything. Ill intentions on the part of the father who raped the woman, or ill intentions on the part of the judge?
No, the touch on the part of the father, like, why
Well,
his actions
Well, because you can, yeah, because in the Hanafi madhab, if you, like, you can't have, basically, you can't be married to a woman with whom your father had sex, not just been married to.
Yeah, but it was like done forcibly, like not.
Yeah, well, that is why it is a controversial point between the different mazahib. That is why, I personally felt, and this is why I mentioned it, because التخير والتنقل, for the faqih it's called تخير, to choose. I personally believe that the honorable Hanafi judges should have basically considered the Shafi'i position to avoid all the drama that took place in India and caused all this grief. And just, when you have like a public case of this nature, just don't be confrontational with the sensibilities of the masses if there is a way to avoid that confrontation. Because that confrontation usually does not lead to good places.
So what if they just ignored that rule and just stayed married?
What is their recourse? Would they have recourse there, especially like in India or in some place, or in any place, in Egypt? I know there's not.
Well, if they immigrate to a Shafi'i district, well, so stop here. Inshallah, take your questions in the question and answer session. Subhanaka wa bihamdika, ashhadu an la ilaha illa anta, astaghfiruka wa atubu ilaik.